I want to thank you so much for joining us tonight for the virtual civic engagement series sponsored by the nonpartisan organizations of the League of Women Voters serving the communities of Warrenville, West Chicago, Winfield, Wheaton, and Carroll Stream, and also the Robert McCormick House located at Cantigny Park in Winfield. I'm Barb Lyman's coordinator for the Civics series, and we're so happy tonight to welcome back, by popular demand, I might add, Professor Steve Schwinn, who will offer insights regarding some of the major issues that are to be decided by the United States Supreme Court now that oral arguments before the court have concluded. Professor Schwinn is a professor at John Marshall Law School and is a frequent commentator on issues related to constitutional law and human rights. He is also the co-founder and co-editor of the Constitutional Law Prof Blog and an occasional contributor to other publications. By now, I'm sure you are all Zoom pros, but just to let you know, we have muted all your microphones, so if you do have questions, we encourage you to use the chat box located at the bottom of your Zoom screen during Professor Schwinn's remarks. Hopefully, time permitting, all will be answered by the end of the program. There is a lot to cover, even with today's new events, so without further ado, Professor Schwinn.
Thank you so much, Barb. Can everybody hear me? Maybe give me a thumbs up. Yeah? All right, great. It's great to see so many faces. This is exciting. I'm, again, Steve Schwinn. I teach constitutional law, comparative constitutional law at the University of Illinois, Chicago, John Marshall Law School. And this is, Barb, what, maybe our fourth year doing this? Third or fourth year?
Third year.
Third year, okay, yeah, very exciting. I tell Barb every year, this is really, truly is one of the highlights of my year. And I'm just so thrilled to be with you yet again, and truly honored to be with you. So thank you for the invitation. I'm just delighted to be here. We have a full plate of things to discuss tonight. Barb, even before I begin, as I'm looking at my view, I can see that I don't have a clock on my screen somehow. So I'm gonna have a bit of a challenge. Oh, there we go. Okay. I was going to say I was going to have a bit of a time management issue, but I think we're going to be fine. What I'd like to do, if it's okay with everybody, is talk about some highlights at the Supreme Court, starting with what happened this week and kind of working backward, looking at some of the bigger cases, and maybe talk about some of the trends that we're seeing at the court or that we might likely see at the court. And leave time for discussion and Q&A. And if history is any guide, I would say let's leave plenty of time for discussion and Q&A. I think that's really where our best ideas come out. Barb, I am more than happy to take questions as we go, if that works for you, or not, whatever format you think works best. So if folks want to send questions, through there's a chat function, I think, right?
Right, it's at the very bottom of the screen. When you put your cursor over the bottom of the screen, you'll see a little bubble and it says chat. And it's set so that everyone will see the questions that anyone asks. So if I see one, and it sounds like it's appropriate time, I'll stop and ask.
Awesome, perfect. And if anybody's having any technical difficulty, if I'm not coming across or if I lose video or something like that, please just let Barb know and she'll let me know and we can correct the malfunction. I've got to say, I've been doing a lot of Zoom and WebEx recently, and knock on wood, I have not had any issues. So I'm hoping that we won't have issues tonight either. So, are we ready?
We're ready.
Let's do this. Wow, what a week. I don't know if you've been following what's going on at the Supreme Court, right? But my head is kind of spinning. We had a couple of major rulings this week that are significant defeats for the Trump administration. And we'll talk about those one at a time. I'll try to put them both in doctrinal and political context for you, and we can talk about what they're going to mean for the future. These are both, well, let me say this. The case that came down today is a somewhat complicated case if we want to get into the weeds, and I think it's actually worth doing that to some degree. The case on Monday, the Title VII case, I think turns out to be a little less difficult, at least in terms of the way the majority ruled on the case. And so let's start with the case today. We'll work back to Monday. There's one other case that the Supreme Court has ruled on so far this term that I'd like to put out there that I think is a significant one we need to keep our eye on. And then we can talk about the cases that the court has yet to rule on and will likely rule on in the next couple of weeks. So let's start with today's case, the DACA repeal case. And what I want to do is kind of set this up because I'm not sure, we may have varying levels of familiarity with what's going on with the DACA program and the Trump administration attempts to rescind the DACA program. So you'll remember that the Obama administration implemented the DACA program, Deferred Action for Childhood Arrivals, during the Obama administration. Now, what the program did was two things. It granted individuals who qualified for DACA beneficiary status, it granted them deferred deportation. These are unauthorized aliens, they're youth, so they were children who were brought to the United States without authorization by their parents, and they met certain other criteria that the administration had established. If they meet that criteria, the first benefit they get is a deferral of deportation. What that means is that the administration would decline to enforce immigration laws against them and move to deport them, would decline to do that for the length of their DACA status, however long that might be. There was another benefit as part of the program, a significant additional benefit as part of the program. If somebody qualified for DACA, not only did they get this deferred deportation, but they also got work authorization and Social Security and Medicare benefits under the federal law. So two things, and it's important to keep those two things in mind as we kind of go through this chronology. Now, if you'll remember from the Obama administration, a lot of people didn't like DACA. And so there were a lot of suits against the Obama administration arguing that the administration exceeded its authority in adopting the DACA program without congressional authorization. And you might remember some of those debates. What the Obama administration was saying is that this is a form of prosecutorial discretion, kind of writ large, right, on a policy level. What the Obama folks were saying is that we are declining to enforce deportation laws against this particular class of unauthorized aliens because we think it's good policy not to do that, which is a typical prosecutorial discretion kind of decision, but the Obama administration was really doing it on a kind of broader policy level. Soon following the DACA program, the Obama administration implemented a parallel program called DAPA, D-A-P-A, Deferred Action for Parents of Childhood Arrivals, basically the parents of the DACA recipients. The Obama administration implemented that program, and that was subject to lawsuits as well. The program operated very similar to the DACA program. Its core features were the same, except that it applied to a different class of individuals. Now, as it turned out, one of these cases got up to the Fifth Circuit challenging the DAPA program, the United States Court of Appeals for the Fifth Circuit, and the United States Court of Appeals for the Fifth Circuit issued a ruling that said DAPA is illegal insofar as it grants work authorization and Social Security and medical benefits to beneficiaries, period. The Fifth Circuit did not say anything about deferred deportation. Now, I know we're kind of getting into the weeds, but in order to understand today's decision completely and to understand the ramifications of it, I think we need to be there. So if you have questions as we go through this, it's perfectly understandable, and I'm more than happy to take them or repeat something that you might have missed. Just let me know. So we have this Fifth Circuit ruling that upholds a portion of DACA, that is the deferred deportation, but says another portion of it, that portion that grants benefits, that's illegal. Okay, fast forward to the Trump administration. The Trump administration says, we want to rescind the DACA program. We want to rescind it, the Trump administration says, because it's illegal. Okay. Now, the Attorney General, Jeff Sessions at the time, wrote a memo that said DACA is illegal based on the Fifth Circuit ruling, that I just talked about. And the Secretary of the Department of Homeland Security then moved to revoke DACA based on the Attorney General's legal analysis, which in turn was based on that Fifth Circuit ruling. But the Secretary for Homeland Security revoked all of DACA, not just the work permit and the medical and Social Security benefits. She revoked the entirety of DACA. So lawsuits challenged that revocation. That's what we heard at the Supreme Court, and that's the decision that came down today. Now, the short version is the court ruled in a fairly close ruling, well, a very close ruling, a 5-4 ruling. The court ruled that the Trump administration violated federal law in revoking the entirety of DACA, D-A-C-A, childhood arrivals. What the court said in particular is that in revoking the DACA program, the administration violated a law called the Administrative Procedure Act. Again, we're getting kind of into the weeds here. The Administrative Procedure Act is simply a federal law that provides for a particular process that agencies must follow before they can adopt new policy or new regulations. And what the court said today is that in revoking or rescinding the DACA program, the Department of Homeland Security violated the Administrative Procedure Act. In other words, it didn't follow the rules in revoking the program. Here's why. What the court said is we need to look at the department's justification for its action at the time that it took its action. Well, the department's justification for its action at the time that it took its action was that DACA was illegal, but only insofar as it granted work permits and Social Security and medical benefits, having nothing to do with deportation. And yet, the secretary, although that was the justification, the secretary went ahead and rescinded the entirety of DACA. Okay, and that's where the court said that the administration violated the Administrative Procedures Act. What it said was the secretary had authority based on her justification to revoke a portion of DACA, but not the entirety of DACA. The court said that was, in the language of the Administrative Procedure Act, that was an arbitrary and capricious decision and therefore illegal and invalid. Now, the court said something else kind of along the way. It also said, if the administration is going to do this kind of thing, it's got to consider the reliance interests of DACA beneficiaries. It's got to at least consider that. Now, that may or may not be a determinative factor for the agency in deciding whether to revoke DACA or not, but the agency's at least got to consider it. And they didn't consider those reliance interests in this case. So I read that as kind of a hat tip to the DACA beneficiaries saying, you know, we understand that you have a reliance interest in this and, you know, you've been in the United States under DACA protection with your work authorization. And we understand that over time you come to rely on that and that the administration, if it's going to wholesale revoke this program, it has to consider your reliance interest.
Steve, we do have one question. Can you explain reliance interest?
Oh, yeah, of course, sure. So what the court said is that DACA recipients had been granted DACA beneficiary status by the Obama administration as early as, 2012, when the program came into play. And so these folks have come to rely on their DACA status and rely on the idea that the government is not going to move to deport them or to withdraw their work permit or take away their Social Security benefits. In other words, maybe thinking about this in a different way. In other words, DACA recipients today in 2020 are kind of comfortable in their DACA status here in the United States. And the secretary has to consider that in a wholesale revocation of the program. And again, the court said that that may or may not be a determinative factor, but the secretary at least has to consider those reliance interests as a matter of Administrative Procedure Act law. Let me talk, before we talk about a couple of other opinions in the case, which I think we need to keep an eye on and are kind of interesting. Let me just say what the opinion today does not do, because there's a lot of stuff kind of flying around the media and the Twitterverse discussing this opinion, I think, in some perhaps incorrect ways. And I want to be sure that we understand what the court's done here. First off, it's not a constitutional case. The court did not rely on any particular separation of powers kind of analysis or anything like that. It really is a pure Administrative Procedure Act case. Now, the APA, of course, does have to do with separation of powers, but the court didn't couch its decision in constitutional terms. That's one thing that I think is important to remember about the case. Another is that the court said nothing about whether DACA itself is legal or illegal. It said nothing about that. So we have no idea, according to the Supreme Court, if DACA is legal or illegal. And then a third thing to remember, the court left the door open, and in fact, in some ways, gave an invitation to the Trump administration to go back to the drawing board and try a do-over, to try to do this again. What the court said was, you know, the administration can move to revoke DACA or rescind DACA, but if it does it, it has to do it in the right way, consistent with the Administrative Procedure Act. That's really all the ruling is saying. Now, as a practical matter, will the Trump administration go back and do that? For what it's worth, my own 2 cents on that question, I highly doubt it. The timing's not great going into the fall election, and so I don't think that this is going to be a high priority on the Trump administration's list. But there's something else going on here. The way the Trump administration had litigated this case from the get-go, it was trying to, I think pretty clearly, trying to achieve a policy result without taking political accountability for it. Let me explain that. What it was trying to do is rescind DACA, but do it by claiming that DACA is illegal. And so the Trump administration's claim throughout the litigation was, our hands are tied. We have no choice but to revoke or rescind DACA, and we're doing that in the name of the rule of law, because DACA, after all, is illegal. Well, they don't have precisely that justification anymore. And at least not exactly in those terms. And so if the Trump administration is going to move forward and rescind DACA, it really needs to put its political neck out there and take political responsibility and be politically accountable for its decision to do that. And I have no idea what the political calculus is in the White House. They might think that's a good idea, or they might think it's a bad idea. But I think this close to an election, my guess is they're probably not going to want to touch it at this point.
One more question.
Of course.
Why did the Fifth Circuit ruling have such power? Why did it not go to the Supreme Court?
Yeah, that's a terrific question. And I actually neglected to tell you a piece of the story. The Fifth Circuit ruling did go to the Supreme Court, but if you'll remember, the court for a long period of time, in the waning days of the Obama administration, was an 8-justice court. This was after Justice Scalia died, and Senate Majority Leader Mitch McConnell was refusing to take up a nominee for a replacement in the last year of the Obama administration. So when the Supreme Court considered the Fifth Circuit ruling, this had already been on the docket before Justice Scalia's death, the court divided 4-4. What that meant was that the Fifth Circuit ruling stays on the books, but it only has precedential effect within the Fifth Circuit. It's not a nationwide ruling. And so a 4-4 split on the Supreme Court, it's an unusual thing because obviously we ordinarily have 9 justices, but the 4-4 split basically left the status quo. It left the Fifth Circuit ruling on the books as it was and really said nothing about the DAPA program. The reason that the Fifth Circuit ruling has such weight and heft is because it's the highest court ruling on the legality of the DAPA program. In other words, it was the best law that Attorney General Jeff Sessions could have relied on when he wrote the memo that then DHS relied upon to revoke the program. You know, the Fifth Circuit ruling was hotly controversial, obviously, with a 4-4 split at the Supreme Court. Yet the Trump administration thought that it was the right ruling. And so for Jeff Sessions to write a memo that relies on the Fifth Circuit might seem odd and strange, but given the kind of strange way that case came up through the system, it makes sense, even if we may or may not agree with the result. Justice Sotomayor went with the majority in this case. So Chief Justice Roberts wrote with the four progressives, and Chief Justice Roberts wrote the opinion, which I think is significant here. I'm going to loop back to that in a second after we round out talking about this opinion, because I think there may be something going on here that we want to keep our eye on. Chief Justice Roberts writes the opinion with the four progressives joining, including Justice Sotomayor, but then Justice Sotomayor writes a separate concurrence saying that the Trump administration rescission of the DACA program also violates the Equal Protection Clause in the Constitution. Here, the Fifth Amendment equal protection principle of the Constitution. And what she said is it violates that because it's so clear that the Trump administration was discriminating by race in rescinding the DACA program, in particularly discriminating against Latinx individuals. And she said that's a form of discrimination that's cognizable under the Equal Protection Clause. Notably, she wrote only for herself. Nobody else joined that opinion, even the progressives on the court. The conservatives on the court, Alito, Thomas, Kavanaugh, Gorsuch, they ruled, or they argued, I should say, in dissent. What they said is, look, DACA was illegal from the get-go. And so for the Trump administration to rescind DACA, it doesn't need to comply with the Administrative Procedure Act. It simply needs to rescind DACA. If DACA is unconstitutional, an action of a prior president is illegal, then the subsequent president ought to be able to revoke it, as kind of the short version of their argument. And again, the majority rejected that because the majority really got into the weeds here and read the rulings quite carefully, read the administration's action quite carefully. Now, I said Chief Justice Roberts writing the opinion has some significance. If everything that we're discussing here kind of rings a bell, that's because this looks an awful lot like what happened in the census case from last term, where the administration, if you'll remember, sought to put a citizenship question on the census form. Is the person answering the census, are they a citizen of the United States or not? And they sought to do it in a way that looked rather suspect. And you'll remember, or maybe you'll remember, that Chief Justice Roberts wrote in that case as well, that the administration's action, again, violated the Administrative Procedure Act because of the way the Trump administration went about trying to get that question on the census. Now, the court didn't say that the Trump administration couldn't do it, just like in this case. It could, but if it does, it has to follow the rules. Now, we can contrast these two most recent cases with a much earlier case in the Trump administration dealing with the travel ban. The travel ban opinion, you'll remember President Trump came into office promising to ban immigration by Muslims. And then over time, his administration, and through different versions of the travel ban, kind of identified a handful of countries from which travel would be restricted. Challenges then went to the Supreme Court, and the Supreme Court, with Chief Justice Roberts, upheld the travel ban against a kind of similar sort of claim. There was a religious element to that claim, but the procedural piece of it was there as well. And so what does all this mean? I think what it means is that we have 5 justices on the court, which by all accounts is a politically conservative court. We have 5 justices who are going to hold the Trump administration's feet to the fire and make sure that they comply with procedural rules when they do things. That may have implications when we look at cases that have yet to be decided, like the tax cases dealing with President Trump's tax returns. We'll talk about that in a few minutes. I'm not sure the ruling today telegraphs anything about the tax cases, but I think it does say with certainty that we now have 5 justices on this conservative court who are perfectly willing and able to hold the administration's feet to the fire and ensure that they comply with administrative rules and procedural rules as they make policy. I'm just going to pause and take a breath here, and if anybody has anything to say or weigh in or questions, I'm happy to take them. We doing okay? Okay, so the other case that came down this week was a case that did not directly involve the Trump administration, but did involve a federal law, Federal Civil Rights Act, Title VII of the Civil Rights Act of 1964. Title VII bans discrimination by an employer against an individual employee, and here's the language, because of sex. Because of sex. Now, in 1964, most people, most meaning the vast majority of people, thought that that language, because of sex, meant that an employer could not discriminate against somebody because they were biologically male or female, period. Well, the cases that came to the court and that the court ruled on Monday asked the question, does this language, because of sex, does it also encompass discrimination by sexual orientation and transgender status? This is a question that the court has not ruled on before, although the EEOC has an opinion on this, and the EEOC said that it does protect sexual orientation and transgender status. At the same time, you might have been paying attention that the Trump administration moved with some administrative rules to interpret non-discrimination acts so that they don't cover sexual orientation and transgender status. So there's kind of this percolating debate, both at the administrative level and in the courts, about sexual orientation and transgender status, but we've never had a ruling on these issues from the court. The court issued a 6-3 opinion saying that Title VII does ban discrimination by sexual orientation and transgender status. The author of the opinion was Justice Gorsuch, who is a President Trump appointee and a rigorous textualist, and it was joined by Chief Justice Roberts and then the 4 progressives. What Justice Gorsuch said was this idea of because of sex means but for causation. But for causation in the law means that a result could have come from more than one causes. And one of those causes, so long as one of those causes was the but for reason for the result, then the result came because of that cause. The example, that's kind of abstract. The example that Justice Gorsuch gave in his opinion is if there's a traffic accident where 2 cars collide in an intersection because one of the cars failed to yield at a red light, but the other car failed to properly signal a turn. Well, both the failure to yield the red light and the failure to signal the turn are but for causes of the accident. In other words, you can have 2 or more causes of the same results. Now that matters in this case because what the employers were saying is, we didn't discriminate by sex, we discriminated by sexual orientation or transgender status. We, the employers, fired the employees because they were either gay or transgender. Didn't have anything to do with sex. The court rejected that. What the court said was, no, you might have fired them because of transgender status and sexual orientation, but in doing so, you also fired them because of sex. And what the court said was, think of it this way. If with regard to sexual orientation, there were a male employee who was attracted to females, well, that person would not be fired. But if there were a female employee who was attracted to the exact same female, then that female employee would be fired. And what the court said is that's the very definition of discrimination by sex. The employer is treating the male employee differently than the female employee with respect to the woman that they're both attracted to. Similar reasoning goes with transgender status. What the court said was, if a man presents as a woman, the employer will not fire the man. But if a woman presents as that same woman, I'm sorry, the other way around. A woman presents as a woman, they will not be fired. But if a man presents as that same woman, they would be fired. What the court said is that's the very definition of because of sex, treating people differently because of their sex. And so what Justice Gorsuch said for the court was this idea of transgender discrimination or sexual orientation discrimination is tied up in sex discrimination. You can't really separate the two. And so the employers here, according to Justice Gorsuch, they actually discriminated by transgender status and sexual orientation, sure, but in doing so, they also discriminated by sex in violation of Title VII of the Civil Rights Act of 1964. That's a huge ruling.
Question, does this ruling also include the recent cancellation by the Trump administration of health benefits to these same groups, which would be discrimination?
Yeah, that's a great question. It doesn't by its plain terms and its own force, it doesn't. But to the extent that any other federal civil rights statutes or regulations use that language because of sex, the courts will interpret that language in exactly the same way that the Supreme Court has now interpreted it in Title VII. And so I haven't looked carefully at the language in the Trump administration's rule. It's a good bet because so many of these civil rights statutes use that language because of sex. It's a good bet that it does. And that while the ruling by its own force doesn't affect that, the administration will have to change back that rule and cover sexual orientation and transgender status. And so too with any other federal civil rights statute, say fair housing, for example, where language says because of sex. This is a very significant ruling. What it means is nationwide now, transgender individuals and gays and lesbians enjoy non-discrimination protection on a federal level, and they don't have to rely merely on state and local governments for anti-discrimination laws. There are good parts of the country that don't have anti-discrimination laws by sexual orientation or transgender status. Now individuals in those parts of the country will be able to sue under Title VII and protect their non-discrimination rights.
How does it differ from the wedding cake case of several years ago?
Yeah, that's a fantastic question too. I think, Barb, what's likely to happen next after sort of the dust settles from Monday's ruling, I think we're likely to see employers asserting as a defense to these Title VII claims a religious liberty claim. It's going to go like this. If, say, I'm an employer and I have an employee who comes out as gay and I fire the employee because they're gay, they sue me now under Title VII, and it looks like they're going to win. Not so fast, because maybe what I say is being gay and hiring gay people violates my religious practice, violates my religious liberty, my free exercise of religion. In other words, the exact same claim that we're seeing from the cake bakers, the flower decorators, all the wedding providers for same-sex weddings. The Supreme Court hasn't sorted that out yet, and the lower courts are still kind of working it through. These claims are largely going against the religious freedom defenders, but that doesn't say anything about what's going to happen in these Title VII cases when employers undoubtedly assert free exercise of religion or a Religious Freedom Restoration Act type claim against the Title VII action that's brought to them by gay and lesbian employees that they've fired. And so I think you put your finger on a really hot issue that we're likely to be seeing in the next couple of years, probably come back to the court. The court's going to have to wrestle with this and figure it out. And as it turns out, there's a case on the docket next term that doesn't deal directly with this issue, but does deal directly with the free exercise clause itself and asks the question, how do we interpret the free exercise clause? And that question may touch on these issues. I'm kind of throwing a lot at you right now, but there's just so much going on in this area. And I think Monday's ruling, while it's a ruling that I think that many of us can be very excited about, I think also, let's be cautious, because we're going to start to see these religious liberty defenses against these claims. It's a good question.
Other questions?
So the dissent in this case, said, this is sexual orientation and transgender status discrimination, period. That's what it is, and that doesn't overlap with sex discrimination. What the dissent said is, here's an example. If an employer fires a man for being attracted to other men, the employer would similarly fire a woman for being attracted to other women. And that's sexual orientation discrimination. The employer would not fire a man who's attracted to women or a woman who's attracted to men. The touchstone, according to the dissent, is sexual orientation or transgender status. What the majority had to say about that, I kind of mentioned a second ago, but it might have slipped by. What the majority said is Title VII protects individual rights. So the relevant question here is not what would the employer do with regard to a straight man versus a gay man, but what did the employer do with regard to the gay man at issue in the case? And narrowing it that way, looking at the individual claim, the majority said that this is really about sex. All right, are we hanging in there? We doing okay?
We're hanging in. No other
All right.
questions.
I'm going to mention just really quickly, and I've got my eye on the time. I do want to leave plenty of time for questions and discussion. So I'm going to mention really quickly one other significant ruling that came down from the court a couple of months ago. You may have been following this either this term or in an earlier term, and I don't remember, Barb, we might have talked about this case before in one of our earlier sessions. This is the cross-border shooting case, where you have a Border Patrol agent on the U.S. side of the border with Mexico, who shot and killed a Mexican youth who was playing around with his friends in a concrete culvert that runs between the U.S. side and the Mexican side of the border. What happened here is the Border Patrol agent shot and killed the Mexican youth who was on the Mexican side of the border. The youth's family then brought a civil rights claim against the Border Patrol agent under a court-created doctrine that for shorthand we call Bivens. This relates to a Supreme Court case that authorized this kind of action. For a constitutional violation, the case has kind of been up and down, kicking around the courts in various iterations, but the Supreme Court finally ruled this term that the plaintiffs don't have a federal cause of action for a civil rights violation against the officer. The ruling's significant because it denied relief to this particular family, and that many see as I think quite rightly see as a tragedy. But it's significant too because the Supreme Court has now taken one more step in limiting this doctrine that authorizes victims of federal civil rights abuses to bring claims in federal court. Now, if that idea sounds kind of familiar, it might be because you've been following the qualified immunity debates that we've been hearing so much about with the Black Lives Matters marches and the recent spate of police brutality. Qualified immunity is another court-created doctrine that provides almost blanket immunity for state officers who commit constitutional violations against victims. The Supreme Court took up or considered a handful of qualified immunity cases recently And many of us thought, maybe the Supreme Court will reconsider its doctrine in this area and more freely allow these civil rights claims to go forward. The Supreme Court this week said, no, we're not going to take up those qualified immunity cases. And so the state of the law stays the same. What that means is whether your civil rights are violated by a state officer or a federal officer, it's really, really hard to bring a constitutional claim against those officers. And I wanted to mention this cross-border shooting case because I think it's important in its own right, but it also overlaps with some of the stuff that we're reading in the media about, again, the spate of police violence most recently. And so I think has some bearing on those issues as well. I have a number of other cases that I think we probably want to talk about. So many that I'm looking at my notes. I think my guess is that many of us are going to be perhaps most interested in the cases seeking to get President Trump's financial records and taxes. And these are some of the most important cases, maybe the most important cases of the term, not because they may or may not reveal President Trump's tax records and financial documents. That, in my view, is not why these cases are important. They're important because the Trump administration, in inserting itself into these cases, has raised issues that really push the boundaries of the separation of powers in ways that we have not seen, and invite the court to do the same. If the court does the same, I think we're going to see a dramatic expansion, not just for the Trump administration, but for all future presidencies, a dramatic expansion of presidential authority at the expense of congressional authority. Let me explain. So these are two cases. We'll take them one at a time because they raise very different issues, even though we're going for the same thing, President Trump's financial records. One case involves 4 different subpoenas from 4 different committees in the House of Representatives, subpoenas to President Trump's accounting firm, not to President Trump, but rather to President Trump's accounting firm. These committees are seeking this information, President Trump's financial records, to explore all kinds of different things, everything from self-dealing allegations to emoluments violations to anything else that President Trump's financial records might reveal as a violation of federal law. These 4 committees in the House of Representatives have said, we want to take a look at Trump's tax records, and the best way to get them is to go through President Trump's accountant. Now, here's where things get a little interesting. President Trump at that point actually inserted himself into the case. Okay, remember, he wasn't a party. He inserted himself into the case to argue that Congress lacks authority to get his financial records. His argument goes like this. What he says is that Congress does have some oversight authority, but its oversight authority really has to be toward the end of enacting legislation, because that's what Congress does. That's what a legislature does. It enacts legislation. And so any oversight authority that Congress has to be working toward the end of enacting legislation. The language of the court is it has to have a legitimate legislative purpose. And President Trump says these requests don't have a legitimate legislative purpose. Now, that's an extraordinary claim because almost everything has a legitimate legislative purpose. And even if it doesn't, the courts are really reluctant to poke their nose in and judge whether Congress has a legitimate legislative purpose. This is something that we just don't see a lot of litigation on because it's such an easy question for the courts. Of course, Congress has a legitimate legislative purpose so long as it says so. So That's an extraordinary claim. President Trump lodges a related claim and says that what Congress is doing in requesting these records is not really legislating, which is the role of Congress. What it's really trying to do is execute the law, which is the role of the executive. What it's trying to do is dig around and find out if there's a legal violation here. But that's not what Congress should do. That's what the Department of Justice should do in the executive branch of government. So the separation of powers comes in a couple of ways in this case. Congress, of course, is arguing, hey, we can investigate whatever we want to as long as it's within our lawmaking power. And this is well within our lawmaking power. We make ethics rules all the time, for example, for officials in the executive branch of government. And this is just an exercise of doing that. So the ruling in this case is going to be really important with regard to the comparative powers between the president and Congress. And again, the argument that the Trump administration has made in this case really is quite extraordinary. And if the court bites, if the court accepts it, we're going to see what I tell my students is it's a separation powers issue where you can almost feel those plate tectonics moving. I mean, it's just so enormous what this would do to the difference in separation of powers between the presidency and Congress. It's related to some other things that we're seeing. You'll remember from the impeachment proceedings and even after the impeachment proceedings, the orders from the White House were that no administration officials will testify before Congress on impeachment or on anything else without the White House's say-so. Now, that's pretty extraordinary. And what it meant is that Congress had to use, in particular the House of Representatives, had to use its subpoena power in order to get anybody to actually come forward. And those cases will drag out in the federal courts for years. And what that means is that Congress really doesn't have oversight authority if the administration wants to drag its feet. Now, that practice itself is going to have a lasting impact on the separation of powers. What it does is signal to the next president, Democrat, Republican, or otherwise, that they too can frustrate Congress's oversight function simply by dragging their feet. And there's very little that Congress can do as a practical matter in response to that. The other case dealing with Trump's financial records comes out of New York, and this is an entirely different scenario, raising an entirely different claim, but equally breathtaking. This was a subpoena by a local grand jury in New York to President Trump's accountant, the same accounting firm, for President Trump's tax records in order to investigate campaign finance law violations. In particular, what the grand jury was investigating is whether President Trump's payoffs to individuals to keep quiet about their sexual relationships in the run-up to the 2016 election, whether those constituted illegal campaign contributions under New York law. The grand jury was convened. The grand jury issued a subpoena to President Trump's accounting firm for these records to help them investigate that. And again, President Trump inserted himself into the case. He was not a party to the case, but he inserted himself into the case, this time to argue that the president enjoys absolute categorical immunity from criminal processes, which is a breathtaking claim. The court has never come close to ruling on anything like that, although the Justice Department has long held that the president is categorically immune from criminal prosecution while in office. That's a controversial ruling, but that's what the Justice Department has said for a long time. President Trump seems to be taking that a step further and saying that the president is categorically immune from all criminal process whatsoever, even a criminal investigation, because of his office as president. Again, a sweeping claim. If the court were to accept that, it not only would be making new law, but really shifting the balance of powers in dramatic ways by giving the president a new categorical immunity that literally puts the president above the law. Now, what the president is saying is, I'm head of the executive branch. I'm head of the branch that enforces the law. And so I ought to get to call the shots with regard to law enforcement. And moreover, to prosecute or even investigate the president while the president is in office is going to distract the president from a ton of other functions that the president needs to be attending to. Those aren't entirely crazy arguments in the sense that they've been kind of kicking around for a while, but they've also been arguments that the Supreme Court has rejected in other contexts in their most categorical form. So what's the Supreme Court going to do with this case and the other congressional subpoena case? I really don't know. It's hard to say. But again, looking back to today's ruling, we do know that Chief Justice Roberts, through today's case and some other cases, is sometimes willing to side with the progressives on the court, even against the Trump administration. And so while I think it's hard to say that today's ruling telegraphs anything about the tax and financial cases, we do know that we have 5 justices on the court who are willing to step up and truly hold the president's feet to the fire. And that may have significance when the tax cases come out. They may come out next week. That's a possibility. I actually expect them to come out, let's see, more likely the week after. But at this point, it's anybody's guess.
Just a general question. How many more cases will the court rule on take on before the November election?
Yeah, that's a really good question. I should know that. I think there are fewer than 24 that the court has yet to rule on. They're not all big, significant cases. There are a couple. Again, I want to leave plenty of time for Q&A, and I'm conscious of the time. So maybe I'll just mention the other ones fairly quickly, and we can move to Q&A, and I can discuss them if you like. The court does have a couple of cases on its docket for next term that it will hear starting in October, but it won't issue rulings in those cases before the election. So it's really the outstanding cases from this term in the next week or two that we'll be looking to, that will have some play or another in the 2020 election. Let me mention just really quickly a couple of other cases that are on my radar screen that have yet to come out that I think are important, maybe politically important, or maybe simply important in terms of sort of the, I guess, constitutional law. So one of those cases is
Steve, because
yeah, of course.
We have 2 questions regarding the Trump case.
Sure. Yes.
Do you think rulings in cases with Nixon and Clinton will affect the ruling?
Yeah, it's an outstanding question. They will affect the ruling. It's not clear to me exactly how. So the Clinton case involved the president's liability in a civil action while the president is in office. Remember, Paula Jones sued President Clinton for sexual harassment before President Clinton was elected to office. The lawsuit was pending while he was in office. And what President Clinton said was, I'm absolutely immune from civil liability and a civil lawsuit while I'm in office because I'm just too busy. Like, I don't mean to sound trite about it, but literally that was the constitutional argument. And the Supreme Court flatly rejected that. It said, no, that's crazy. The president is going to be subject to a civil lawsuit just like anybody else. And the courts, to the extent they need to work around the president's busy schedule, the courts can easily do that. And that's exactly what they did in the Paula Jones lawsuit. And we kind of know the rest of the history from there. The deposition that President Clinton was subjected to, the remote deposition, and his lie or fabrication during that deposition, which then ultimately led to his impeachment. With regard to the Nixon case, so Clinton's going to have some use, but its use is going to be limited in the Trump case because the Clinton case was about civil liability. The Trump case is about criminal liability of the president while in office. And we can imagine why the Clinton case would be strong for one side or the other, given the difference between civil and criminal liability. I think both parties have played the case well. The other case, the Nixon case, is the executive privilege case. What the Nixon case said was that there is such a thing as executive privilege, that high-level advisors to the president, high-level communications with the president can be privileged under certain circumstances. And what the courts will look to in determining those circumstances is the need for the communication on the one hand, and on the other hand, the need to keep the communication secret. So for example, if the high level communication involves a national security issue, for example, there's a really weighty need to keep that secret. But on the other hand, if it just involves, sort of random murmurings, there's really no particular need to keep it secret. If it involves a criminal case, there's a real high level need for that information. But if it involves a congressional investigation, there's probably a lower level need for that information. Now here we have a grand jury subpoena for the information, so we know we're in the criminal process. That's probably a weighty interest on the one hand. On the other hand, President Trump is saying, well, I do have something like executive privilege over my financial records, but he hasn't well articulated why. And so it's not clear how the court's going to weigh that out to the extent that it rules on executive privilege here. And just to be clear about this, the way the privilege would run is between President Trump's accounting firm and the president, right? That's the communication that we're concerned about here. And President Trump he'd have to win on a pretty aggressive executive privilege kind of claim in order to get some traction out of Nixon in this case. Now that hasn't stopped the President Trump from asserting just an extraordinarily aggressive form of executive privilege under Nixon across the board. I had mentioned earlier that standing orders from the White House are that administration officials don't testify before Congress. The administration's reason for that is executive privilege. That doesn't flow really at all from the Nixon case, but that's the direction that the administration has taken executive privilege under Nixon. And so the stakes here are really high. If the court recognizes a more robust executive privilege, I think we all have to recognize that that's going to apply not only to President Trump in the future, but also any other president that we might like or not like, with information that we might want or not want, right? When the court makes constitutional principles like this, it makes them not just for the sitting president, but for all future presidents as well. What I always tell my students is we can test the integrity of our constitutional convictions by switching the politics, right? And making sure that we come up with the same answer. And if we do that, then we can be pretty sure about the integrity of our constitutional position. But if we treat parties differently, maybe we ought to go back to the drawing board and take a second look at how we interpret the Constitution.
A couple of additional questions. If the Supreme Court rules against Trump in the tax cases, does that mean we'll see his tax returns before November, or can he?
Fantastic question, and I'm really sorry, I should have mentioned that. Almost certainly not. Here's why. First off, in the grand jury case, there's a grand jury secrecy rule that's going to be hard to get around, and even if it's get aroundable, the Trump administration has proved extraordinarily adept at dragging its feet and dragging those kinds of issues out through the courts in a way that it could easily drag that out beyond the 2020 election. As to Congress, the congressional question, I think, is a little closer. If Congress gets its hands on President Trump's financial records, then the question is, how soon can Congress actually see those records, right? And then beyond that, how soon will they be able to share them with the public? And that's both of those questions are a little uncertain. Again, the Trump administration has proved extremely adept at dragging its feet on these kinds of questions, but other questions as well. It's done a fantastic job of running the clock on so many of these issues. And given how close we are to the election, and And, you know, quite frankly, the entire House of Representatives is up for election. They don't really want to be in Washington trying to get President Trump's financial records right now when they want to be out campaigning. So I'm not sure the timing works. I'm not sure the politics work. It's just not sure. But I would not put money on seeing the records before the 2020 election, even if there's a win for Congress or for the grand jury in these cases.
If Trump loses the election, will any of these cases be moot, or will all the cases be ruled upon by others?
They won't necessarily become moot, but the tradition is that claims, I want to say the tradition, but we really haven't seen claims like this against other presidents. The Trump presidency is extraordinary for so many different reasons. But let me say it this way, in similar kinds of instances, the tradition that we've had in this country is that when a president loses, that's their loss, and then they kind of go away and resume their life as a civilian, and the government doesn't prosecute them or seek to lock them up at that point, because the sort of tradition is the voters have spoken, they've elected the person out of office, and we as a country are going to kind of move on. So while in theory these things could all remain live and active, it's not. They could sort of drop by the wayside just because the prosecutor in New York or the congressional committees decide to move on.
Great. We have a general question, but I thought I'd ask that after you finish your other preview.
Oh, sure. So let me just say really quickly some of the other cases that are up for review. And we can, if anybody's interested in talking more about these, I'm more than happy to share some additional facts or arguments or law or kind of what's going on in these cases. So one of the cases comes out of Louisiana. It's the June medical case dealing with access, a woman's fundamental right to access to an abortion. The June medical case is interesting because of the way it follows on almost exactly the same case that the Supreme Court ruled on a couple of terms ago in Whole Woman's Health, coming out of Texas. Texas and Louisiana both had laws that required physicians who are performing abortions to have admitting privileges at a local hospital within a certain distance of the abortion clinic. As a practical matter, what this meant, for a variety of reasons that we can go into if you're interested, as a practical matter, what this meant was that it became much more expensive or even entirely prohibitive for abortion providers to stay in business in Texas. And because of that, the Supreme Court in the Texas case ruled that requirement unconstitutional. Now, Justice Kennedy was on the court in the Whole Woman's Health case, ruling that law unconstitutional. Now, virtually the same case comes back to the court, but from Louisiana, not Texas, and with Justice Kavanaugh, not Justice Kennedy. And so there's a really significant question here about whether the court is going to go with its ruling under stare decisis principles from Whole Woman's Health, or change course, or do something else and surprise us all in this case. It really is, we really just don't know in June medical. And I can say more about that if anybody would like to talk more about it, but I think just in the interest of quickly mentioning the other cases, I think I'll not say more. So a couple of other cases that we're looking at, the Little Sisters case. This is a long-running dispute that we've seen kind of go up and down through the courts throughout the country with regard to the contraception requirement or guarantee under the Affordable Care Act, or Obamacare, and in particular the religious exemption for the contraception guarantee. The Trump administration expanded the religious exemption to the contraception guarantee pretty dramatically, and they did it unilaterally through administrative action. And so the question in the case is, did the Trump administration have authority under law to dramatically expand the religious exemption for the contraception requirement in the Affordable Care Act? And even as I'm saying that, I'm realizing how sort of twisted and complicated this case is. And again, it's a case that's been kicking around in different versions for a long, long time in the courts. This is just the most recent iteration of it, and is significant because it deals with the Affordable Care Act. And it's important to pay attention to those cases in general, but it also is likely to tell us something about the scope of religious liberty and the scope of religious exemption from laws like a contraception mandate. Two more cases that I have my eye on this term that have yet to come out. One is a case out of Montana, where Montana has a scholarship program that is offered to families who want to send their children to private schools. The scholarship program currently is not available under Montana constitutional law. It's not available to families who want to send their children to private religious schools because the Montana Constitution prohibits that. Families that would like to send their children to private religious schools have brought suit and said that that bar in the Montana Constitution violates our free exercise rights to send our kids to a private school of their choice, including a religious school. And so this is one of those really interesting and fascinating cases that pits the Establishment Clause and Establishment Clause concerns against Free Exercise Clause concerns, and really tests what the court calls a play in the joints between those two clauses. We do have a relatively recent case from the Supreme Court on something kind of similar to this, but it doesn't really necessarily telegraph a ruling in this case. This case really is the reason that many of us are watching it is because the way the court goes in this case could open up religion to a lot of different government opportunities that religion could previously have been closed out from. And so it'll be interesting to see what the court does with this one. And then finally, and this is a case that really has flown under the radar, but I think is extremely important. The question in the case is with regard to the Consumer Financial Protection Bureau, which is a new federal agency in the Obama administration under the Dodd-Frank Act as a reaction to the financial crisis in 2008 and all the nonsense that led up to the financial crisis in 2008. Congress created the Consumer Financial Protection Bureau, gave the director authority to direct the Bureau, and then said that the president cannot fire the director of the CFPB except for cause. The question is, did Congress too far intrude into the role of the executive by insulating that office from at-will firing? By creating an independent Consumer Financial Protection Bureau. And that has huge ramifications for the federal government and the way that it's structured. It has huge ramifications for the separation of powers and Congress's role in designing the executive branch. And has huge ramifications doctrinally for a number of different constitutional theories that have been floating around out there. So this is it's kind of hard to overstate how important this case is, but given everything else on the court's docket, amazingly, this one has just not gotten a lot of attention. So I'm keeping my eye on that one as well, and we'll see what the court does in the next couple of weeks. I apologize for not leaving more time for Q&A, but let's just open it up at this point.
Well, we have a question from Kathy, and she would like to know, what would it take for the SCOTUS to expand beyond 9 justices? Is that a possibility?
Yeah, great question. Oh, fantastic question. I was just thinking about that this morning. It would merely take legislation. So the fact that the court is at 9 is, it's a tradition but it's not any sort of hard and fast rule. As it turns out, under Article 3 of the Constitution, there's no particularly set number of justices on the Supreme Court. Congress has changed the numbers over time since the founding of our country, but it's been at 9 for quite a long time now, and so that's been our tradition. You might remember or have studied in the FDR administration when the Supreme Court went through a period of striking New Deal legislation as unconstitutional. FDR threatened to pack the court by creating a new seat on the court for every justice over a particular age that didn't retire. The effect of that would have been to put justices on the court, expand the number of justices on the court, and put new justices on the court that would uphold rather than overturn the New Deal legislation. The court made a switch then in the late 1930s and actually started upholding this legislation, not overturning it. We sort of colloquially refer to that as the switch in time that saved 9. And so Congress never went through with FDR's court packing plan. Whether Congress would have the appetite for doing it today, I think is a question. And we can all think about the politics in the Senate versus the House of Representatives. Remember, legislation has to pass both houses and be signed by the president. This legislation too would have to meet those requirements, and that may be a tall order after the 2020 election. So we'll see. I know there's a lot of talk out there about expanding the size of the court. The Trump administration has done, in conjunction with Senate Majority Leader McConnell, has done a truly inspiring job of stacking the federal court with the federal courts as a whole with President Trump appointees. They've done this just at a ferocious pace and have been extraordinarily effective at doing it. And so, after the 2020 election, they will either continue doing that, or they have written a playbook for a Democratic president to do that. And I expect that will happen for sure, whoever is in the Oval Office. But whether the court itself expands in the number of seats, I guess I'm a little more skeptical about.
Donna asks, is there a way for the Supreme Court to rule that appointing unqualified judges to the federal bench is unlawful? Would such a lawsuit be possible? We stumped the expert.
You stumped. Well, I'll tell you, I could just say no, but you've actually kind of interested in this question. I think the answer has got to be no. So by tradition, the judicial nominees are vetted by outside organizations before the president sends them on to the Senate, whether they're going to the lower federal courts or to the Supreme Court. And by tradition, this is a role that the American Bar Association has played. Now, the George W. Bush administration moved away from looking to the ABA rating as the gold standard for judicial nominees. Obama brought that back to some degree, but the Trump administration has moved decidedly away from the American Bar Association rating system and has a slate of candidates that it has identified with the assistance of other outside organizations, and has gone ahead and nominated them and again gotten them through the Senate with amazing, remarkable efficiency and speed. That's the president's prerogative. That's in Article 2 of the Constitution, and the Senate's advice and consent role is there. That's something that is between the president and Congress. So, we might like that politically, or we might dislike it politically, but it's something that the president has the power to do. Now, if the president starts putting up objectively unqualified judges, or judges who have financial conflicts of interest or pose other ethical problems on the bench, there's nothing beyond voting our senators or voting the president out of office that we could do. But I will say the judicial branch itself has judicial ethics, a code of judicial ethics, and it enforces it within the judicial branch. Now, the judiciary can't kick a judge off the bench. A judge can only be removed through impeachment. But if the judicial ethics guides does guide judges on the federal bench, and to the extent that a judge is running afoul of judicial ethics or financial conflicts of interest or just doing a really bad job judging, they could be subject to impeachment. And we have seen a number of federal district court and federal circuit court judges impeached over time in our country's history. So the remedy there really is impeachment, I guess, is a kind of a long way of saying that.
I have no other questions on the chat. So I would like to thank you so much, unless someone's giving me a high sign that they're madly typing in 1 second. I can't thank you enough for coming back again and alerting us and educating us as to possible things that are going to happen. Some pretty dramatic cases happening this term that could change the future for sure. So thank you so much. I'm going to turn the meeting over to Judy.
My pleasure to spend time with you. And I only regret that we can't see each other in person at the beautiful facilities where we've done this year in and year out. But it's so nice to see your smiling faces on my screen. I've got, I think, 24 of you up right now. And it's just such a delight to spend this time with you. So thank you